Good afternoon. Thank you all for being here today. As you all know, Judge Singheiser issued an order yesterday, a very well-reasoned order, vacating the conviction, the murder conviction of Christopher Dunn, and also ordering his immediate release. As we argued in our motion and based on the evidence we presented at the hearing on this matter, the court concluded that based on the recantations of the two key witnesses against Christopher Dunn in his 1991 murder trial, there remained no evidence to support his conviction, and therefore granting our motion to vacate was the proper ruling. I want to take this opportunity to thank the Thompson Colburn Law Firm, and specifically my colleagues Booker Shaw and Layla Houston, and as well as Rachel Moore, who can't be here today, but they, along with me, presented the evidence for our team at trial. I also want to thank the legal team from the Midwest Innocence Project, Tricia Rojo Bushnell, as well as Rachel Wester, who have long represented Mr. Dunn in his fight for his freedom and have played a huge role in us achieving this very, very favorable outcome. Also, I would like to thank Mr. Dunn's family, his wife Kira, who's here with us today, and his mother and his sisters and his support network that really stood by him all these years and supported him and never gave up their belief that justice could be obtained in this case. As you are all aware, Mr. Dunn isn't here with us today because he remains confined. In our view, the judge's order was very clear, ordering his immediate release. And based on that, we are considering what approach and what legal options we have to obtain Mr. Dunn's relief. But that's something that we have not made any decisions on at this point. Now, I would like to give Mrs. Dunn an opportunity to say some words.
Thank you, Mr. Bohr. First of all, I want to thank Mr. Bohr and his team, Judge Shaw and his amazing team, and the Midwest Innocence Project, and all the dedicated, heartfelt people who work there. We're just so grateful. This has been such a long fight for decades, and without them, we would not be here today. We are overjoyed, and at the same time, we're also afraid to really exhale until Chris actually takes his first free steps and feels the free ground against his feet. When that happens, I think all these feelings we've been holding on to for so long will finally erupt. But thank you for being here, everyone, and we are hopeful that the next time you hear this about this case, it will be the news of Chris walking up as a free man into the world, finally, after 34 years of wrongful conviction.
With that, I am happy to take any questions.
Mr. Gore, what's the process moving forward here in terms of when Christopher Dunn does get released, and what happens if there's an appeal? Does that prevent his release until the appeal is, I guess, satisfied, or?
All right. Well, there's a former Missouri Court appellate judge here, so I'm gonna let Judge Shaw address that.
So at this point, we're considering our options, but with regard to your question, the law provides the Attorney General with no right of appeal. And so we are hopeful and optimistic that should they proceed with the notice of appeal that they file, that we will be able to move very quickly to get his release.
But just during that time, would there be any holdup in his release?
Well, we're kind of in uncharted territory because, as I said, there's no legal basis for them to have filed the appeal in the first place. So we are hopeful that the court will recognize that and move expeditiously to allow his release.
And then do you happen to know when that release would be? Is that something that's been scheduled yet at this point?
We just don't know.
So they have appealed, or you expect them to?
They filed a notice of appeal, which means we expect that they will appeal.
If they don't have the legal recourse to do so, how are they able to do so?
Well, people do a great many things that they are not, they don't have a legal basis to do. We would file motions with the court, and we're anticipating and kind of working out our strategy today as to what our next steps are, but certainly we would move to dismiss or strike the appeal.
Judge Shaw, would you call this an election stunt on the Attorney General's part to file this appeal?
I certainly wouldn't. I don't want to get into any kind of political motivations of what drives this Attorney General in terms of their opposition to our efforts here. So I can't speak to that.
Katie, do you have a question?
Yeah, I guess I'm curious, when you say options, what does that mean? Would an option be to try to stop the appeal from moving forward at all, to fight it in the appeals court? I mean, can you just kind of go through, in general, what some of those options could be?
So we're considering all of our options at this point, and you know, when we file whatever we file, then you'll see which option we settle down. I don't think it's productive to sit here and try to create our legal strategy in front of a group of the press.
Well,
Have you talked to Mr. Dunn at all? And what is his reaction to all this?
I have not spoken to him, but his legal team at the Midwest Innocence Project has been in regular communication with him.
Sir, this is the second time this month that the Attorney General has taken action to keep someone in prison who's been deemed wrongfully convicted. In the first case, the judge threatened the Attorney General with contempt of court. Is that something you can ask for, or is that something you would consider asking for?
At this point, we're still considering our legal options, so we haven't settled on anything. And like I said, I'm not going to formulate our legal strategy as we appear here at this press conference.
In the final judgment, are there things that kind of stood out to you about this ruling?
Well, as I said, obviously we were extremely pleased with it. I thought it was very well reasoned. I thought the court's focus on the fact that the sole evidence presented against Mr. Dunn at the original trial was the testimony of the two key eyewitnesses who at that time were 12 and 14. I thought he did a very careful analysis as to why their recantations of that testimony was credible. And I also thought his reliance on the expert witness, which is testimony that wasn't available in any of the other proceedings, the expert witness of the eyewitness testimony expert, I thought his reliance on that and kind of pointing out how really the identifications in this case had every indicia of unreliability when you consider things like opportunity to observe, the alleged presence of sunglasses on the face of the shooter, the darkness of the night, the age of the witnesses. So I thought that was that testimony was helpful to the judge, and I thought the way he tied it to the evidence was very powerful.
Just as a matter of logistics, will the next step play out at the circuit level, or are we talking about appeals court?
That's something that we're still considering. We're considering all of our options. This is not, as Judge Shaw pointed out, these are issues of first impression.
Do you worry about the Attorney General? It seems like there's been a continued pattern with innocent cases, including Lamar Johnson and whatnot. Do you worry about what the AG tends to be a buffer in these cases?
This is my only case, and I kind of take cases one at a time, and I'm focused on the issues here, and I'm focused on achieving our objective. One of those objectives have been achieved, which is our motion to vacate has been granted, and the other part of the judge's order was that he be immediately released. So we still have work to do to obtain that relief, and that's what we're focused on.
And this would be your first one under, as circuit attorney, correct? Conviction overturned?
It is, yes.
Attorney Gore, I got maybe a two-part question. The Attorney General, like she just pointed to Sandra Henney in Kansas City, he just tried to stop her release. And with the other Lamar Johnson that was just released, we understand that Kim Gardner kind of set the precedent to get innocent people freed in Missouri. Is this an attempt maybe by the Attorney General to kind of overturn that, or is it something that you guys can kind of fight through?
I don't, you know, in this single case, they opposed our motion. We had a 2-day hearing where all of the evidence was presented, and we prevailed. And now our goal is simply to obtain the relief that the court has ordered, which is the immediate release of Mr. Dunn.
I know you're still trying to figure out the jurisdiction, but if you had to come back here to hash this out, could Chris be brought from Licking to here to St. Louis City Jail?
So if your question is, if there's, as a result of further proceedings, if there's a hearing held here, could Mr. Dunn be brought in for that hearing? I do believe that the court has that authority. They brought him in for the hearing on the motion to vacate, so I do think the court has that authority.
Can I ask Karen, do you have any thoughts about this effort to keep your husband behind bars when the judge has already ordered him to be free?
I think Ms. Dunn would prefer not to take any questions today. Any other questions?
Judge Shaw, did this experience make you miss the courtroom?
I miss the courtroom every day.
Are there any other cases you're looking at right now?
We are reviewing a number of cases on conviction integrity issues. I'm not going to talk about what specifically those are. Our conviction integrity unit is headed up by former Supreme Court Justice George Draper, and we're taking a look at those cases. At this point, we are focused on cases where we think there's potentially evidence to support actual innocence.
For the appeal, is there a specific timeline that they have to file an appeal on or deadline?
My understanding is they filed the notice of appeal, and so once that's on file, they will proceed by whatever schedule is set by the Court of Appeals. But of course, it's speculative at this point to think about what exactly is going to happen procedurally, because we haven't decided what our approach will be.
If there are no more questions,